friends, and welcome to today's webinar hosted by the Medical Alley Association and brought to you by Frederickson and Byron. I'm your host, Bobby Patrick, the Vice President of Strategic Growth and Policy for the Medical Alley Association. And today's conversation centers around an issue that is critical for health technology companies throughout Medical Alley: optimizing your patent strategy. A strong patent strategy includes an analysis of competitive patents, but there is an inherent tension between that need and the company's legal budget. Today's discussion will focus on best practices for tracking and analyzing competitive patents, along with the patent landscape and freedom to operate analysis that satisfy the obligations to avoid willful patent infringement, all while staying within those budget constraints. And so with that, let me introduce today's participants. First, we have Sean Solberg, shareholder and patent attorney for Frederickson and Byron. Scott Johnson, shareholder and patent attorney for Frederickson and Byron, and Bob Atkinson, patent counsel and managing partner for B2IP Consulting. Today's webinar will primarily be a conversation between the participants, but we certainly welcome your questions. So please use the Q&A function at the bottom of your screen to submit them, and I'll insert them as part of the discussion as we go along. And so with that, Bob, I will turn it over to you.
All right, well, did we want to do a brief introduction of each of us? I'm going to tell you just a little bit about myself, just so you understand where my perspective comes from. So I was 5 years research and development engineer at SciMed, later Boston Scientific, 5 years in-house patent counsel, 5 years private practice. And for the past 17 years, I've been doing startup companies here in the Minneapolis area. So my perspective is a little bit more influenced by business. I think Sean and Scott have strong legal backgrounds and their perspectives are a little bit different than mine, but they all come together in some very meaningful practice tips that I think and hope we can offer you today. So maybe we can start out by talking about the basic difference between patentability and freedom to operate. You can have a patent on your product, but that doesn't mean that you don't infringe someone else's patent. Both are possible, and it's very common. I was talking to a client this morning about a concept they have on, let's say it's an implantable electrode, and they're very interested in pursuing it for a specific clinical indication, but there's a method patent on that clinical indication. And there's an example of having some IP on your product, but having an infringement issue that you need to resolve. Now we'll work with him and figure out ways to design around that patent. We'll get into that more later, or the need to license it, whatever it might be. But it's important to understand that a patent gives you the right to exclude others from making, using, and selling your invention, whereas a freedom to operate position establishes your freedom to make and use and sell your own product. So you don't have to understand the legal rationale in terms of the difference between the two, but what you do need to know is that they're both essential. You want to get patent protection on your product, but you also want freedom to operate. And I've heard a lot of arguments about, do we really need to do freedom to operate? But I've yet to meet an investor or a shareholder that wants to pump money into patent defense litigation as opposed to building a business and generating revenue. So it's not intuitive, but just remember that freedom to operate needs to be on your essential to-do list. And medtech is one of the most litigious industries in the US. So failure to do freedom to operate analysis is kind of like walking into a minefield with your eyes closed. Sean?
Great, thanks, Bob. So I'm Sean Solberg. First off, I want to thank Medical Alley for organizing this presentation for us. And I want to thank Bob for joining us as well and bringing the business perspective. I'm the patent prosecutor in the conversation. Bob has worn many hats over the course of his career. I'm more the patent nerd and the counselor for IP strategy for quite a few startups and medical device companies. And so that's the perspective I bring. I'm going to provide here a specific example of the difference between patent protection and the ability to commercialize, or what's called freedom to operate. So we're going to use a small and quick example here to kind of go through the nuts and bolts of the difference between the two. And we're going to use this example of the stent because, hey, let's use a medical device. So let's assume that Scott invents the stent. He goes to his patent attorney, and this is the patent claim. Let's just assume this is claim number one. This is his claim number one in his patent for the stent. So it's an expandable graft with these three limitations. So any device that satisfies these three limitations is infringing Scott's claim. And this circle over here is intended to represent the space that Scott can exclude others from playing in, from commercializing in, based on this claim. So let's say Bob comes along and says, you know, the stent is good, but I've got a better idea. I'm going to create the drug-eluting stent. So Bob goes to his patent attorney. Let's say he gets a patent, and this is claim number one from his patent. Now, notice the difference. We're going to switch back here for a second. Notice the difference here is one limitation, and that is D at the bottom. So here's Scott's claim. Here's Bob's claim. D is the drug-eluting agent, or the active agent that is eluted from the device. But notice where that leaves Bob's protection within Scott's world. Okay, so Scott can still, because Bob's invention is a drug-eluting stent, let's go back to Scott's claim. Bob is infringing on Scott's patent. Bob is infringing on Scott's claim. Bob's invention has all three of these limitations, the tubular member with a first and second diameter. So that leaves Bob in a situation where he has a patentable invention and maybe multiple patents, but Bob is in a situation where he cannot commercialize. Now, of course, if you want to get into the details of what happens at this point, you can see that also Scott can't commercialize the drug-eluting stent. So if the drug-eluting stent is the technology that is in demand, if the efficacy of the drug-eluting stent is such that it makes it a much better device than the stent itself, then you're going to see some movement and probably a cross-license, or there might be a lawsuit depending on what actions are taken. But the key point here is to emphasize the fact that Scott can come along and invent something. Bob can come along and improve upon it, but that doesn't mean Bob is automatically, because he has a patent, able to commercialize his technology. And that's kind of the critical point here. So we wanted to get kind of that basic introduction in as we then move towards what is the tightrope that is created in the patent world when you need to focus on both patent protection and freedom to operate, that is, ability to commercialize your technology, and what happens when you need to focus on both of those things, kind of the catch-22 that you walk into. So if you are a smaller company, and I know we have a lot of attendees from a lot of different types of companies and a lot of different people with different roles, but if you are a smaller company or a startup, you start with the issue of money. And so you understand most of the time, hey, I want to file a patent application. I want to protect my technology. But the other question that's going to come up from any investor, and I know Bob can relate to this and mentioned it already, sophisticated investors are going to ask whether you've considered freedom to operate. Well, in that situation, it kind of creates a scenario where, well, you need money in order to file your application and to do some sort of freedom to operate analysis or landscape analysis. You need money to do that. On the other hand, when you talk to investors, they want you to have done that already before they give you money. So that's the first kind of monetary catch-22 that arises. And then the next step, as I know Bob will talk about as well, it relates to the catch-22 created by willfulness. And that's for every company of all sizes. And that is, once you do decide, I need to look at the competitive patent landscape, I need to decide, what that looks like from the standpoint of what are my risks. Then you run into a situation where you might discover some patents that are fairly relevant to your technology, and it raises the question of whether you might be infringing. And then willfulness law kicks in, as we're going to talk about in a minute. and creates additional potential obligations for you as far as how you behave moving forward.
Yeah, Sean, I think it's important to understand, and I suspect most of the audience recognizes that investors are sophisticated enough to want to look at a freedom to operate analysis. And the idea that you can go in with your eyes closed and you're worried about finding a patent that's a problem. Well, if you don't do the homework, I tell you the investor will in their due diligence process. So, you know, as a startup, you mentioned the catch-22 in terms of budget. There's a lot you can do on your own without getting a patent attorney involved initially. You know who your competitors are going to be. You can find all of their patents through the USPTO website by looking at assignments. Gather all those patents, try to narrow it down by keyword if there's hundreds of them. But take a look at those and read the claims. You're not focusing on the detailed description or the drawings. Look at the claims and interpret them in an open way. Do they read, do they have the elements that you have in your device or your product? If the answer is yes, then you want to give a patent attorney a call. If you're not sure, you want to give a patent attorney a call. But I think there's some inexpensive means that you can exercise to get a preliminary analysis done. I also think it's helpful for people making investment. They oftentimes want to see a freedom to operate search being conducted by someone other than the company. So me personally, when I'm starting a company, I'll do my own homework. I'll research all my competitors, look at their patents, understand what they have, what they don't have. But I need to give that some objectivity. So I hire out a searcher in DC to look at patents in that area, in that landscape, and collect those and go through those as well. It's fairly inexpensive, and it gives your freedom to operate analysis some credibility. So I think that is worth spending the money on. I usually spend about $2,000 to $3,000 doing it. Oftentimes you can reduce the cost by doing a little bit of the homework yourself and giving the patent searcher some clues about which patents might be important to expand upon in the search. Other things to think about. Also think about the freedom to operate or landscape analysis as being evolutionary. So if I'm starting a company and I don't have the product completely defined, I haven't collected all the customer requirements, I haven't done a design review, I haven't done any of that. So as you progress through product development, you're going to want to update your freedom to operate analysis, update your search, and make sure you're not running into any roadblocks. But the freedom to operate analysis should start on day one, and investors expect it. If you haven't started it, if you haven't done it, it's not catastrophic. I think you do it, understand what your risk exposure is. If you don't, I think investors are going to use that to devalue whatever investment they put into the company. If they see a significant freedom to operate risk, their pre-money valuation is going to be lower than if it was completely free and clear. Thanks, Sean.
Yeah, those are all great points. I would add to that one of the things to keep in mind that does lend itself towards this idea of saving some money up front and maybe doing as much as you can yourself is, you know, the sophisticated VCs are going to want to know that you did pay attention to this, that you did look at it, but they also know they're going to do their own as well in the course of the due diligence. If they get that far in the process towards investment, they will most likely do their own separate search and analysis, have their own counsel do that. So there's no need for you at the beginning to do something quite as intensive. So what you're recommending, Bob, is exactly right. Something a little bit more informal, maybe more in-house to begin with. Have your own search done potentially, review that yourself. I would say then the next step would be if there are any red flags, or even if there aren't, probably a good idea to bring in patent counsel to spend a minimal amount of time looking at at the stuff you've looked at to make sure there hasn't been anything missed that a patent attorney might recognize. But all of this ties back into kind of the situation. If you are in the fundraising mode, that the VCs are going to want to hear that you paid attention to it, that you've tried to identify any red flags, but they all are also going to do most likely an independent analysis as well. So there's no sense in reinventing the wheel right up front by being too thorough and spending too much time or money on it. Identify the red flags, be able to talk about that with the investors.
You know, Sean, that brings up another point that I'd like to touch on real quick. If you're going to do some of the homework yourself, be aware that you're creating a body of evidence. So everything you put into writing, you know, if you highlight a claim in a patent, if you circle it and say, oh, wow, we got a problem, or infringement, or whatever it might be, you're creating a body of evidence. It's important to take that into consideration because that's going to rise to the top eventually. And one way to think about it is engaging an attorney. You can trigger attorney-client privilege. So those are the conversations you have with your attorney. You don't have them in a business group at the company, at least not in writing. The other thing to think about in terms of putting things in writing is when you're pitching to a venture capitalist or other investor, don't comment on your freedom to operate analysis and things like that. All I do is say freedom to operate position established, and leave the rest for a conversation with the attorneys, not an exchange of emails or a slide deck on freedom to operate. Go into depth on your patent portfolio, you know, brag about that till the cows come home, but all your slide deck should have is freedom to operate established, and the rest is off the record.
That's a great point. That's a great point. So where does that get us then, as far as how you handle this competitive patent landscape situation, regardless of whether you're a small budget or startup company, or whether you're a larger company who's trying to avoid any issues with willfulness down the road? Where do you start? And I think Bob kind of talked about this, whether it's in-house or whether you work with your patent counsel to start the process, it's a good idea to do a preliminary competitive patent landscape. What do the competitors have? And are there any issues in there? And that then the concern becomes, what if there are some patents that are fairly relevant? What if there is some concern that you might be infringing? That's when you walk into this willfulness situation, and we want to talk a little bit about the structure of that. And that's the reason we haven't let Scott talk yet, is because Scott's the litigator. So as he's going to tell you, we don't want to have to work with Scott if we don't have to, but we need Scott when we need him. And so Scott's going to talk about willfulness. I don't know, Bob, if you had more to add to that.
Well, I think if you do all of your homework here and you do the things that we're suggesting, you're going to avoid willfulness, which is great, right? Tell me any investor that wants to pump money into litigation absent a patent troll. I would be quite surprised. So staying out of the realm of willfulness is smart. Staying out of infringement risk is smart. So as Sean suggested, doing this landscape analysis earlier is better, because through product development, you're going to be aware of these patents. You can design around them. You can eliminate a feature that's problematic. You can add a feature to help get you distinguished from other people's patents. There's all kinds of things you can do. You might change your indications for use. So for example, someone might have a patent on a very specific clinical indication. You might go for a different clinical indication or a broader clinical indication. It's also going to influence your marketing strategy, what you say your device does, what it doesn't do. So if you identify these issues up front, there's all kinds of things you can do through development to avoid the risk of litigation down the road. Thanks, Sean.
Yeah, thank you. Those are all great points. This is the crux of the situation, is when you get to this point, because as you said, Bob, the ideal world is you do the landscape analysis early so that it can lead you down the path of where you go with your commercialized technology. On the other hand, unfortunately, it doesn't always happen that way. And that's when you need guidance from someone like Bob, someone like me, and then hopefully not someone like Scott, in trying to avoid the willfulness situation where you already have quite a bit of your technology developed, and then because of budgetary reasons or whatever, you haven't yet become fully aware of what the patent landscape looks like. You do that, and then you've got to decide how to proceed from there. So let's talk then a little bit about willfulness and the case, the law of willfulness, and how it influences how we behave, how companies behave as they move forward in this world of, hey, I might be aware of a patent or two I'm concerned about.
All right, so now I get to talk. As Sean and Bob have commented earlier, I'm usually the guy that you don't want to have to hear from because patent litigation in many ways is the big bad wolf, right? Especially when you're a startup or a small company, your capital is at a premium. And you don't want to be spending money on patent litigation. You want to be spending money on launching products, developing products, building up marketing plans and getting products to market. I am not the person you want to be spending money on. And patent litigation, unfortunately, is often called the game of kings because the average costs of patent litigation in the United States are anywhere between $2 to $6 million for patent litigation. They suck up time from your employees. They suck up resources from your management. They distract you from the main purpose of your business. What we're going to talk about now is if they don't go right, there are some dire consequences associated with those things. At a minimum, damages in patent cases are a reasonable royalty. So it's as if you would have negotiated a license at the start when you began infringing. What would the royalty have been that you would have paid for that product? That's your minimum amount of damages. The maximum amount of damages is generally lost profits. Now, there are weird cases where royalties can exceed some profits sometimes, but and it's usually not your lost profits that are at issue, it's the other side's lost profits. So if you're a startup and you're trying to get into the market and you're going to sell your products at below market rate, so to speak, your profit margin may only be 15%, but your competitor's been making 30%. Patent damages can hit you with a 30% profit margin as the measure of damages. So you want to try and avoid these suits. That's why doing this FTO analysis up front is very important. The worst case scenario is you lose your case. And not only do you lose your case, but you didn't do an FTO analysis. You were aware of the patents and you proceeded anyway and said, you know what, I can do this. We'll see if they come after me. You can be found liable for willful infringement. Willful infringement is, as the slide says, sort of where infringement occurs, you're aware of it, and you disregard the patent rights of others. The damages for this can be pretty severe. The courts can, and the jury will determine if you're a willful infringer. The court gets to determine how the damages are affected by that. So the courts can treble those damages. So if you're in a case where the damages in the case, I'm going to keep my math simple. Let's say the damages were $1 million. The court can award the other side $3 million. But the court can also award the other side their attorney's fees. Sometimes attorney's fees can exceed those damages. So you don't want to be hit with willful infringement. It's a really bad outcome for you. How do you prevent it? This FTO analysis that Bob and Sean have been discussing earlier, it's one way to show that you're acting in a reasonably prudent business manner. And that's kind of what courts are looking at. The courts want to see that you took reasonable care and that you respect other people's patent rights. If there was an issue, they want to see that you acted in a reasonably business-like manner and you sought advice of outside counsel or in-house counsel if you have them. They want to look at your history. How did the product come to be? Did you go out and buy the competitor's product and build on it? Or did you independently develop what you were doing? Did you have a reasonable right to believe that you could act in the way that you did? They really do look at all of these things in determining whether or not to assess enhanced damages. And we'll go through the history of willfulness law a little bit here. It has kind of changed over the years. And it's kind of gone back and forth. This is interpreting a statute that hasn't changed over the years. So the case law is just going back and forth. In 1983, we had the underwater devices case, where if you were aware of somebody's patent, you had an absolute affirmative duty to go out and investigate it, see if you did infringe. It required that you take active steps. Go get that advice of counsel. You know, if you didn't do that, it was more likely than not that you could be found liable for willful infringement. That all changed when the the Federal Circuit took up the In re Seagate case, and they added in this sort of new twist. Willfulness had kind of gotten out of hand at the time, and there were a lot of litigations. Everybody alleged willful infringement, and there were some big numbers that were coming out of this. And the court, I think, wanted to put a damper on that. And so they established this objective reasonableness test that basically said, look, if you had a good faith defense, if, you know, it's looking at it now, we can see that there's some good arguments for invalidity or for non-infringement, even if they weren't successful, will take away willfulness. It removed that element of the infringer's intent and the infringer's conduct. It looked at it from a 10,000-foot view, an objective view of, hey, is it reasonable that they had a defense here, that they could have not infringed or not been found liable for infringement? That was the In re Seagate. It had a two-part test. If you didn't have a good faith basis and you acted anyway, you could be found liable for willful infringement, but it had an effect of really removing a lot of willfulness cases. Sorry, you can go ahead, Sean, for the next one.
Sorry, Scott.
No, you're all good. The Halo case came out, and I'll say I'm a patent attorney. I started out sort of writing patent applications. I did a lot of work with startups. I became a certified licensing professional. I do a lot of licensing work. And I've always done litigation, and I really have loved litigation. And that's where my focus is today. And you're a patent geek when you're reading an opinion, and you can see different things in life when you see that opinion. I was watching The Princess Bride with my son the other day, and the Halo decision came to mind. And that's just because, The Princess Bride is about a guy who becomes the dread pirate Roberts, and goes back and rescues his girlfriend and all that stuff. But Justice Roberts, I should say, and I probably shouldn't call him a pirate. I'll deny it if anybody accuses me of it later, but he wrote the Halo decision. And
This is being recorded, Scott.
Okay, that's all right. He uses the word pirate in there 8 times because that's the type of conduct that they're really trying to focus on with this new willfulness standard. Piracy. Are you acting in such a way that your conduct is really egregious? That's what the Supreme Court wants. they eliminated that objective recklessness standard that In re Seagate had established, that the Federal Circuit really liked. And now we're sort of back into that world of subjectiveness. The egregiousness that the Supreme Court sort of decide was, it's intentional or knowing, it's willful, wanton kind of behavior. It really, I think, requires a little bit more than just, it should require a little bit more than you knew about the patent, you ignored the patent, and you launched your product. But those three elements are really what district courts have focused on. That's about all they require anymore. And so the element of piracy hasn't trickled down into the district courts like I think it should have. But the first requirement is, of course, that you have to know about the patent. The risk here has to be known or so obvious that it should have been known. This is the catch-22, I think, that John was talking about a little bit earlier with an FTO analysis. When you do an FTO analysis and you cast a wide net, you're going to get a lot of patents back. It's important to go through those things, rank them, see where you believe your risks are. And I would say, have opinions done on the high-risk things. Do them all separately. But the court has really moved into this, Halo-esque era, and we're seeing the decisions go back to a pre-Seagate era where damages are going up. The likelihood of willfulness being found by juries is going up. And it does make patent litigation even more of a big bad wolf. So the FTO analysis that Sean and Bob are talking about, it is building your brick house. Don't build it out of straw. So that's kind of one of the things that we kind of want to reinforce here is just make sure you have a brick house and not a straw house or a wood house. What's the impact of Halo on startups and small companies? Direct evidence of intent is beneficial. It does help to show, if you did an FTO analysis, it actually helps to show that you respect others' intellectual property, that you don't intend to infringe on their intellectual property because you took that reasonable business step of doing an FTO analysis. Do you have to get an opinion? No. There's no affirmative duty anymore. We didn't go that far back to say that you have an affirmative duty to go out and get an opinion of counsel. Look, a lot of patents are written in technical language. They're not always written in legalese, and they're certainly not always written in simple English. And this is, partly my fault. I used to write patent applications. I get it. But in-house folks, you can look at a lot of these patents and say, that doesn't apply. That's outside of our technical space. It shouldn't cover us. It shouldn't be here at all. That type of analysis helps to show that you aren't intending to infringe on those things. You're narrowing things down. You're going through the process of it all, even if it's in-house by somebody. Even if you get it wrong, the fact that you did it is very helpful in avoiding willfulness. It's okay. Well, I shouldn't say it's okay to get it wrong. You'll be in patent litigation if I have to say it's okay that you got it wrong. But if you do get it wrong and you're in patent litigation, going through the process properly may often save you from a willfulness finding. So do it. It's a good investment. You don't always have to go outside and get opinions of counsel. I know, again, capital is key. Opinions of counsel cost money. And if you do that for 100 patents, you're going to spend a lot of money on getting opinions of counsel and getting a really solid FTO analysis. But you may have spent a lot of money that you should have been using for marketing purposes or for product launching purposes or whatever else. So you do have to balance those things. In-house filtration, so to speak, of the prior art is a really good way to do it. You know the business, you know the art, you know what's applicable and what's not. If it's anywhere close, call your patent attorney, call Sean, call Bob, ask them, hey, should I really be concerned about this? If so, and you have conversations first that say, yeah, you know what, we may want to take a little deeper look into this, then pay them to do the opinion. It's worth it to do the opinion. That's kind of where I would draw the line. Sean's going to talk a little bit more about where people have drawn the lines and gotten into trouble, and where they've drawn the lines and not gotten into trouble. And the problem is the case law doesn't provide great guidance right now. I think my takeaway from the Halo decision from the Dread Justice Roberts is don't be a pirate. And as long as you're not a pirate, if you see something of concern, call these guys. But Sean will take you through some more examples.
So before we do that, Sean, I think we got a question in the Q&A that I think is sort of timely here. So I think if it's cool with you guys, I'll just interject this. And Bob answered it a little bit in the Q&A, but I think that it's right to put this in front of the group. So if I found a patent that I may infringe, but the patented technology or product is not commercialized, do I have FTO? If not, how do I address it?
Yes, you have FTO. There
Hey,
are,
Scott,
yeah, go ahead, Bob.
I answered this by text or on the Q&A
Oh, you did?
chat thing, and I said no. And here's the reason I said no. My understanding of the question is that there's a patent out there that someone else's patent. You have an infringement issue with that patent, but the patent owner has not commercialized it. So do you have freedom to operate? I would say probably not, because you still infringe that claim. Maybe the patent owner down the road decides to commercialize something falling within that claim, or maybe they just see a competitor practicing their invention and want to get some money for it. So maybe I misunderstood the question, but
No, I think you understood the question and I misspoke
Okay.
when I gave my answer. I thought, do I have an FTO? I thought, yes, you need to get an FTO opinion.
oh yeah. Yep.
You need to go through the FTO analysis.
Yep.
Absolutely. In fact, most patent cases today involve what we call non-practicing entities, to be nice to them. And non-practicing entities, when it's a university, you should call them a non-practicing entity because they're performing a valuable public service in research and development, and advancing the science and technology. The whole purpose of, Article 1, Section 8, Clause 8, to advance the sciences. That's why the patent laws exist. Non-practicing entities who are corporations who have failed and still own patents and now want to somehow monetize those patents, they're kind of referred to as patent trolls, because that's their business model. It's the old doctrine of champerty, where people are investing in litigation, to try and get a return on that investment. Those are the folks that make up most of patent litigation today. They send out cease and desist letters to 80 different companies. I spend a lot of my time, unfortunately, dealing with those folks. You still want to have freedom to operate opinion with regard to those folks, because they have no other business than to sue you. So they may drag you into court. If you get a patent that is owned by a non-practicing entity that is not a university, I would consider that almost a high risk of going into patent litigation. Get that FTO analysis done.
Great, thanks.
All right, so the highlights here from Halo really put more pressure on all companies as a result of the change in the willfulness law. You've now got subjective intent and any knowledge of the patent. And at the time of infringement, which is a key point, because prior to Halo, you could, at the time of litigation, after you have been sued, you could still come up with an FTO opinion and that could actually win the day. That's much less likely now, because what really matters is what your intent was at the time of the infringement, not if you get an opinion much later after someone has threatened to sue you. So that's a critical piece to keep in mind as well, as far as, you know, kind of the structure of willfulness law. Now there's a lot more pressure on doing some timely preparation. As soon as you find out about a patent, it's time to start acting on it. The good news is the egregious conduct focus, and that's what I want to jump into as far as what the courts have looked at. It's got to be egregious conduct. And so since Halo, we've looked at what the district courts and the Federal Circuit has done with respect to the Halo decision and how they applied it to specific circumstances. So it appears to us, because of the egregious conduct requirement or factor, that courts it's not just enough to have knowledge and continued infringement necessarily. Now it might be, but in most of these cases, it's egregious conduct. So what are those behaviors that we need to avoid? First off, evidence of copying the patented technology is definitely a no-no. Any actions that indicate your awareness and concern with the patent. So filing an IPR with respect to that patent, or trying to, for instance, in the second example here, trying to, for a licensor who actually gave out an exclusive license and then tried to regain the rights to commercialize themselves, that was an indication that they were concerned. Another thing to do is to ignore the warning that that this patent may be a concern. If you fail to investigate, if you, for instance, affirmatively tell your employees, or you affirmatively decide not to tell your employees of this potential infringement, that's a significant problem as well. We do have one case here in which there were assertions of copying that were never proven, and the actions were deemed to be sort of standard course for that industry, and no willfulness was found. But again, here's some other examples of awareness, like a rejected license offer, plus again, copying. And then we get into the examples that make myself as a patent attorney make my skin crawl, and that's when you either rely on bad opinion of counsel. So we'll talk in more detail about that. How much depth does the freedom to operate opinion have to go into? What happens if it's a fairly cursory opinion, and what happens if you rely on that? That is a big risk as well. Relying on a cursory opinion that does not actually do a full analysis is just as bad as having no opinion at all, or maybe even worse. Another one is if you ignore your patent attorney's guidance. Again, another one that makes my skin crawl. So these are some examples of the type of egregious behavior that typically occurs, or that courts have found to be enough to trigger willfulness. So we can take from that a little bit of a silver lining, that it's more than just knowledge and continued infringement. In most cases, it's also bad behavior. That doesn't mean you shouldn't do a full analysis of your risks and maybe get a freedom to operate opinion, but it does mean that there is some leeway there, where if you have good intent and you can establish that, that may reduce your chances of being found liable for willfulness. This is the big one. This is kind of the crux of why this topic is so important to me, and one of the reasons why I picked it. This knowledge component that is added in Halo, and the fact that, hey, you have to know about it, and then how did you behave once you found out about it, has triggered some conversation in various communities and in the legal community. Well, if knowledge is a requirement, what if we just ignore our competitive patent landscape? Nothing could be further from that. Would just be a terrible idea. We have at least one case, and maybe a couple of cases, in which they specifically determined that willful avoidance of knowledge, so intentionally and affirmatively telling your employees and your company, we are intentionally not going to be looking at or paying any attention to what our competitors' patents look like. can get you in as much trouble as if you were aware of them in the first place. So this is a critical piece. If you have a situation where you're raising money and you're protecting your technology, and you decide to, and you have investors talking to you, those investors are not going to buy into an approach in which you are ignoring your competitive patent landscape. So a critical slide that I think sort of kind of addresses that situation. So then what do you do if you do discover a patent that you're very concerned about? That's when you need to approach someone like me so we can avoid someone like Scott. So Scott, what are your thoughts on this one?
Yeah, I mean, that's absolutely right. I'll just, look, I'm a litigator. I love to tell war stories. So I'll tell you some of my favorite war stories here. I had a case in Ohio that dealt with robotic equipment. And the lawyer on the other side who said that there was no patent infringement turned out to be a bankruptcy attorney, not a qualified patent attorney, but he was acting as if he was, basically general counsel for this company. But his specialty was bankruptcy law. He was not admitted to practice in front of the Patent and Trademark Office. Didn't have a lot of experience in dealing with patent issues. And he's the one who gave the opinion that the other side relied upon. I had a lot of fun with that, and willfulness was pretty easy to show because he had construed claims incorrectly. He had completely missed how things should be read based on the specification. It was a lot of fun. And if you're on the other side, you don't want the other side's litigation attorneys to be having fun. That's what you try to avoid with an FTO analysis. The reason you choose competent counsel is because you want to mimic the burdens of proof and mimic the invalidity analysis that has to be done. You need to have somebody who understands how to go through a file history, how to read a patent specification, how to read patent claims, how to compare those claims to the actual accused structure. It doesn't matter if you have your own patents on things. That's not what the comparison is. It's not your patents versus theirs. You need to have somebody who understands that and will look at the products that you have commercialized or are intending to commercialize. Just make sure that it is a very thorough analysis. That requires a great conversation with your patent counsel, not only about what you are doing, but what you're planning to do. Take advantage of that time when you're talking to the patent attorney and tell them about your future plans, because the fact that you don't include an element is enough to get you out of a patent infringement accusation. But if you're planning to include that element later on, that may get you back into a patent litigation. And so you want to make sure you have a good, comprehensive conversation with your counsel. And that is going to sort of lead itself into this totality of the circumstances analysis for a willful infringement analysis that shows that subjectively you were taking the reasonably prudent business steps, having good conversations with well-respected counsel, and doing the right thing to try and avoid having to call somebody like me.
So I know that I want to get Bob's take on this because we've done a lot of dense, nerdy case law stuff. And so I want to get back into the real world, but I also see we have some more questions maybe,
Yeah.
Bob?
Yeah, and I think that Bob can sort of touch on what you just referenced in starting to answer one of these questions here. So Bob, I'll direct this at you. Often a choice is to do a landscape analysis or full-blown FTO, which is costly. How does willfulness apply in this case?
Well, let me offer up my perspective. I think it's a great question, and it actually highlights a couple of issues that are important to understand. Number one, the timing of a written opinion And number two, the difference between a landscape analysis and a complete FTO opinion on a specific patent. So in the beginning, you're doing a landscape analysis, you're trying to identify the issues, the risks, and work your way around those patents or license them, whatever it might be, to mitigate your risks. The only time in my practice, and Sean Scott, correct me if you do something different, but the only time I put something into writing is right before I commercialize. And even then, I'm very cautious about it for a couple of different reasons. So by law, before you commercialize, if you're involved in clinical trials, that's not infringement. There's no infringement liability. So no one's going to be able to sue you for damages. But when you commercialize or start to export, it becomes a different thing. So then you want to have things in writing, and that's when it gets very expensive to do a comprehensive opinion. It doesn't cost as much to do the analysis early on, but when you put it into writing with a good attorney, they're going to make sure that it's sound. They're going to have to defend it in court after all. So I usually do a written opinion right before I commercialize. Before that, nothing is in writing. The other reason to think about the importance of not doing it before you commercialize is that you may be acquired by the company that owns that patent. And this has happened a couple of times. We're developing a product, we commercialize, we're looking to be acquired. We have some infringement risk with a big company's patent portfolio. We think it's defensible. So we could get a written opinion on that. But what if they acquire us? Then they have an opinion in hand that says that their patents don't cover our own product that we're selling to them or that they're acquiring. So I usually wait till the last minute to put something in writing, but when it is in writing, it's gospel. It's got to serve its purpose.
Yeah, and I know we've been talking a lot about litigation and willfulness and things, and that's one of the main reasons that you do an FTO review, freedom to operate review. There is another time when I recommend an FTO analysis be done, and that's when your business model is focusing on licensing of products as opposed to just merely selling products. And the reason I do an FTO analysis before we get into licensing agreements is oftentimes licensing agreements include indemnification clauses. And if you want to give an indemnification clause, you better be able to back it up. And so I do recommend that clients do an FTO analysis to say, hey, I don't think there's a risk of patent infringement here. Sometimes doing that will reveal some risks that you need to address, but again, better to know that in advance. So think about it not just in the litigation context and before you do commercial launch of a product, but also do think about it if your business plans are focused on licensing efforts. That is another time when I would say you may want to do an FTO analysis.
Great. Go ahead, Sean.
I would emphasize one more thing, and I know this is what both of you were talking about, but I kind of want to hit this one home. As far as when to do the FTO, I completely agree with what both of you just said. I would also want to make clear to everyone here that it's only if there actually is a patent of significant concern, right? I think that when it comes to the initial landscape analysis, and I know Bob actually said this at some point during that discussion as well, but when it comes to the actual landscape analysis, I would put very little of that in writing. As long as you haven't identified a patent of significant concern, I often with my clients will do the analysis and then we'll show them a summary, whether it's in a PowerPoint slide deck, which is a common approach for me, or in some sort of, and this is where Zoom has become such a wonderful tool because I can discuss with my client without providing anything in writing to them, something that I've retained for myself. And that creates some additional separation as far as what guidance has been provided and what actually has been put into writing. And that's the way we usually, with my startups especially, because it's more cost effective and it avoids a written product that's floating out there that might ultimately be result in waiver of privilege. And then if there are patents of concern, if there is one patent of significant concern, then we can talk about maybe doing the opinion, because as has been alluded to in these questions, and as you guys have said, that becomes very expensive. And this is what we're trying to avoid. So try and be as pragmatic and cost effective as possible, right up to and including that freedom to operate opinion.
Great. So we are just about out of time. And so I want to give each of you a chance to say a couple of words in closing. For those of you who submitted questions, we'll include contact information follow-up as well. So, and with that, I guess, maybe we'll start with Bob and then go to Scott and have Sean wrap us up. So Bob, any closing comments here?
I think we covered quite a bit. I guess I would just say, don't be afraid of the cost of the analysis. Go in with your eyes open. It's going to save you money in the long term. And if you need to spend money on a written legal opinion, that just means you're about to make a boatload of money in your commercial product. So don't be afraid to do this analysis and come out on top in the market.
Scott?
Yeah, I would agree with that. Bob, well said. We've talked a lot today about trying to avoid litigation. I want you to know that my office is down the hall from John's. And so you may try to avoid litigators, but it's always good to get litigators involved in these FTO analyses. And Sean and I talk a lot. And so it's better to have me involved early than later. It's a lot cheaper to do the FTO analysis. Call Sean, we will talk. And you can get that advice early. And to show that you're acting in a reasonably prudent business manner, I guess, I hate to say it, but my takeaway is still, don't be a pirate.
Very easy to remember.
There you
Sean?
go.
I don't want to sound like a football coach, but my final thought is trust the process, right? What we work in a world where we're working with inventors and CEOs and C-level people who are often inventors themselves, and even in larger companies, we're working with inventors and people who are very passionate about their technology. Don't let that passion for your technology blind you towards what your patent attorney is telling you. Don't get too overconfident in the fact that you think you're practicing the prior art, or that this patent that's out there is absolutely for certain invalid. There's a middle ground there, but trust your patent attorney, trust the process of doing the competitive landscape and the freedom to operate. It often becomes a big hurdle if there's a disconnect between what the patent attorney or your counsel is saying and kind of what your knowledge of the technology and what your belief system is, and letting that filter through there in a way that you miss some critical information can cause significant problems, as some of these cases that were in those examples have shown, where they actually disregarded their patent counsel.
Great. Well, thanks to each of you, and thanks to all of you attending, and thanks very much to Frederickson and Byron for sponsoring this. This was an excellent panel and a lot of information. So thank you, everyone. This will be up on our website, so you can watch back if you have any outstanding questions, and we'll see you all soon. Thank you.